Okay, let's unpack this. You've probably heard terms like corporation or LLC thrown around, maybe in the news, maybe someone talking about starting a business.
Hmm.
But have you ever stopped to wonder what truly makes them tick? Why do these distinct legal structures even exist? And what are the intricate rules that govern them, especially when things go sideways, or, frankly, when you need to understand them inside and out for something really demanding, like the bar exam?
Right. And what's truly fascinating here isn't just like the textbook definitions. It's how deeply these legal structures shape everything. We're talking about who's on the hook for debts, how major decisions get made, the whole 9 yards.
Exactly.
So our mission today really is to cut through all that jargon. We want to distill the absolute essentials, give you a crystal clear, comprehensive picture of what you need to know about corporations and limited liability companies. We're drawing directly from the foundational principles. Think of it as uh, your ultimate guide to the legal DNA of commerce.
That's our goal. A truly thorough understanding. We're going on a pretty comprehensive journey today, tracing the life of these entities right from the very beginning.
Right from scratch.
We'll start at that embryonic stage, what happens before a company is even officially a company, and, the initial stumbles that can happen during formation.
Those early steps are crucial.
Then we'll get into the actual lifeblood of the corporation, its stock, how ownership works, how it's structured, how it's traded.
Yeah, the capital structure.
From there, we'll dive into the nitty-gritty of governance. We'll explore the distinct roles, the interconnected responsibilities of shareholders, directors, and officers.
Who does what, basically?
Exactly. And finally, we'll grapple with what happens when disputes pop up, which they inevitably do, when that protective liability shield might fail, and the formal procedures for how these businesses can merge, get acquired, or even,
A
dissolve.
whole life cycle.
We'll wrap things up by looking at some special corporate forms and that increasingly popular kid on the block, the limited liability company, the LLC. So get ready, because there's a lot to explore, and we're aiming for a depth of knowledge that will make you genuinely well-informed, especially if you're facing something like the bar. All right, let's begin at the very beginning, the pre-life stage of a company. This stage, even before the entity officially exists on paper, is often where the first crucial legal complexities really start to surface.
Indeed. It's a critical phase. Before a corporation formally exists, there's often someone called a promoter, hard at work.
Okay, the promoter.
Think of them as the orchestrator, maybe the trailblazer. They're undertaking all the necessary groundwork to actually bring the corporation into being.
Like what kind of groundwork?
Well, they're raising initial capital, scouting locations, negotiating those preliminary contracts for supplies or office space or, all the legwork, all with the singular goal of forming this new legal entity. They're essentially building the nest before the bird is even hatched.
That sounds like a ton of responsibility and honestly a lot of personal exposure potentially. What's their legal relationship with this entity that doesn't even exist yet? And what kind of liability are they taking on?
And that's where the legal tightrope walk really begins. A promoter stands in a very specific legal position. They have a fiduciary relationship with the pre-incorporated entity.
A fiduciary relationship even before it's formed.
Yes. Think of it like being a temporary guardian for something that doesn't yet have its own legal voice or capacity. This means they owe duties of loyalty and care to the entity they're trying to create.
So they can be held liable.
They absolutely can be held liable if they violate these duties. For instance, if they engage in self-dealing, like, say, buying property for the future corporation from themselves at a wildly inflated price. Or maybe just failing to act in the best interests of this unformed company.
Wow. Okay. What about getting paid for all this work? Can they get reimbursed?
Well, here's the rub. A promoter certainly can seek compensation for their efforts and reimbursement for expenses they've laid out. But here's the kicker. They cannot compel the unformed corporation to pay them
Why not?
because, legally speaking, the corporation doesn't exist yet. So it couldn't have directed or authorized those acts. It's a pretty significant risk for those early trailblazers. They're fronting everything.
That's a huge point. So they're doing all this work, taking on this fiduciary duty, but they can't legally force the future company to pay them back. What about their personal liability to, say, third parties? Like if they sign a lease for office space or a contract for supplies before the corporation is officially incorporated?
This is where it gets particularly challenging, and it's a point that often trips people up, especially on exams. A promoter is generally personally liable to third parties for any agreements or actions they knowingly undertake on the corporation's behalf before it's officially incorporated.
Okay, so they're on the hook personally.
They are. And this isn't just a temporary liability that magically disappears once the incorporation papers are filed. It remains even after the corporation is formed and starts operating. The default legal position is the promoter stays on the hook personally.
Okay, that sounds pretty risky. So how does a promoter ever get out of that personal liability? Is there a legal mechanism to pass that responsibility onto the new corporation once it's actually formed and, standing on its own 2 feet?
There's a critical exception, and it's a concept called novation.
Nosation, okay.
The novation is essentially a new three-way agreement. It involves the promoter, the third party they originally contracted with, like the landlord in your example, and the newly formed corporation.
All three have to agree.
Yes, all three parties must explicitly agree to substitute the corporation for the promoter as the party liable under the contract. This agreement then releases the promoter from their original personal liability. Without that explicit formal agreement, the promoter's liability persists.
So no novation, promoter's still liable.
Generally, yes. Now, there's a nuance. If, right from the very start, the third party knowingly agrees to look only to the unformed corporation for performance, really understanding the promoter is just an agent for a future entity that could prevent promoter liability. But honestly, that's a much higher bar to prove in court. Absent that very specific understanding or subsequent novation, the promoter remains personally on the hook.
Okay, so the promoter often carries the weight of these initial agreements. What about the corporation itself? Once it's formed, does it automatically inherit all these pre-incorporation deals the promoter made, even if they were clearly for its benefit?
That's another common misconception. Generally, no. A corporation is not automatically liable for pre-incorporation transactions entered into by a promoter, even if those deals were clearly intended to benefit the corporation.
Huh. So the promoter's liable, but the corporation isn't, initially.
Initially, yes. However, and this is a crucial exception that comes up all the time in practice, the corporation becomes liable if it adopts the contract.
Adopts it. How does that happen?
Well, adoption can be express, meaning the corporation formally accepts liability for the debt, maybe through a board resolution saying, yes, we take on that lease. Or, and this is often how it happens, it can be implied.
Implied adoption.
Yeah, which often happens when the corporation simply accepts the benefits of the transaction. So using the lease example again, if a promoter signs a lease before incorporation, and then after incorporation, the corporation moves into that leased office space and starts operating there.
They've basically accepted the deal by using the space.
Exactly. They've impliedly adopted the lease by accepting its benefits. They've essentially stepped into the promoter's shoes regarding that specific agreement. At that point, the corporation is liable too. Note that adoption usually doesn't automatically release the promoter, though you still need that novation for the promoter to be off the hook entirely. What's truly fascinating here isn't just that promoters take these risks, but how utterly dependent the whole corporate future is on their early, often thankless actions. It's a real legal tightrope walk. One misstep, one forgotten formality can sink a venture before it even officially begins. It just underscores that the corporate shield isn't automatic. It's earned by meticulous adherence to these often overlooked pre-formation rules. Anyone studying this, remember, promoter liability doesn't just vanish at incorporation without a novation or that very clear initial understanding. It sticks.
That's a critical distinction. Okay, so once the promoter has done all the groundwork, navigated those risks, and the entity is ready to take its first legal breath, how does it actually become a real recognized corporation in the eyes of the law?
Right, the moment of creation. The essential step, the true birth certificate of the corporation, is filing the Articles of Incorporation with the relevant state authority, usually the Secretary of State's office.
Articles of Incorporation, got it. What's in them?
This document is surprisingly concise sometimes, but absolutely vital. It must contain specific pieces of information. First, the corporation's name, and usually that name has to include a corporate indicator like Inc., or Corporation, or Corp.
Okay.
Second, the number of shares it is authorized to issue. This sets the maximum ceiling for how much ownership can eventually be carved out and sold.
They authorize shares, right?
Third, the name and address of its registered agent. This is basically the official point person for legal notices. Like if the company gets sued, this is who receives the paperwork.
Okay, an official contact.
And finally, the name and address of each incorporator. That's the person or persons who actually signed and filed these articles. Could be the promoter, could be an attorney, someone acting on behalf of the future company.
What about things like the corporation's actual business purpose or the specific powers it will have? Do those always have to be spelled out in the articles?
They can be, but they're typically optional these days. Most states allow for a very broad statement, like to engage in any lawful activity. But the articles may include a more specific statement of purpose, or list specific powers the corporation possesses, or even limit its duration, though setting a limited lifespan is pretty rare now.
So when does the corporation officially exist?
The key takeaway from a legal standpoint is that corporate existence officially begins once these articles are properly filed and accepted by the state, unless the articles themselves specify a later start date.
Hmm.
And when all those statutory requirements are satisfied, meaning all the boxes are ticked, the fee is paid, the document is filed correctly, what you have is a de jure corporation.
De jure. That sounds important.
It is. It means by law. This is the ideal outcome, the gold standard. It signifies that the corporation itself, this new legal entity, not the individual shareholders, directors, or officers, is legally liable for its activities. That's the robust legal shield everyone is seeking when they incorporate.
That legal shield sounds incredibly important. But what if a corporation puts a very narrow, specific purpose in its articles, say, to operate a bakery, and then later decides it wants to do something completely different, like start developing software? Can it just do that?
That brings us to a concept called ultra-vires actions.
Ultra-virus, Latin, right?
Exactly. Literally means beyond the powers. An ultra-vires act occurs when a corporation, having stated a narrow business purpose in its articles of incorporation, then engages in activities that fall outside that stated purpose. So in your example, if the bakery corporation suddenly starts investing heavily in software development without amending its articles,
That could be ultra-virus.
it could very well be considered an ultra-vires act, especially if the purpose clause was truly restrictive.
And what happens then? Is the action void? Can someone challenge it?
It's usually not automatically void, but yes, it can be challenged. There are three main ways an ultra-vires action can be contested, reflecting different stakeholders' interests. First, a shareholder can file a lawsuit to enjoin the corporation, basically, get a court order to stop it from going forward with the ultra-vires action.
Okay, shareholders can step in.
Second, the corporation itself could take action against a director, officer, or employee who engaged in or approved the ultra-vires act, holding them personally accountable for any losses caused.
So internal accountability.
Right. And third, the government entity that granted the corporate charter in the first place can initiate a proceeding against the corporation, which could potentially lead to dissolution or other penalties, although that's less common for just exceeding purpose nowadays, unless it involves illegality. These checks exist to prevent a corporation from straying too far from its stated legal identity or acting unlawfully.
Here's where it gets really interesting, and it's a point that aspiring legal minds should definitely grasp. Getting everything right from the start, filing those articles correctly, means you're creating that strong legal shield. But what if you try to form a corporation, you go through the steps, but something goes wrong, maybe a mistake in the filing? What happens if the incorporation process isn't perfect, leaving the corporation with some kind of legal defect? How does that impact liability?
That's a critical scenario, absolutely. And one that really highlights the sometimes fine line between personal liability and corporate liability. What happens if the incorporation process isn't perfect, if there's a defect? This directly impacts whether the individuals involved, typically the shareholders or owners, can be held personally liable for the entity's debts and obligations.
So let's take an extreme case. If someone just starts doing business, maybe slaps ink after their company name on a business card, but they make zero actual attempt to file the articles of incorporation, are they personally liable for everything?
Absolutely, unequivocally yes. If a person conducts business as a corporation without making any attempt to comply with the incorporation requirements, no good faith effort whatsoever, they are personally liable for all the obligations of that non-existent corporation. There's no legal protection there at all. They're essentially operating as a sole proprietorship or maybe a general partnership with full personal exposure. No corporate shield, period.
Okay, that's clear. But what about the more common scenario? What if they actually tried to do it right? They went to the state office, they filled out the forms, paid the fee, but maybe they just missed a crucial step or made a technical error and the filing gets rejected or is somehow defective. Is there any leniency then? Do they automatically lose that limited liability protection?
Yes, that's where the law offers some nuances, and frankly, it's often where the real-world legal battles happen. If a person unsuccessfully attempts to comply with incorporation requirements, but they acted in good faith, they may still escape personal liability in two key ways, under specific legal doctrines.
Okay, what's the first way?
The first is through the doctrine of a de facto corporation.
De facto, meaning in fact, right?
Exactly. Think of it like this. If it looks like a corporation, acts like a corporation, and holds itself out as a corporation, the law might treat it as one, at least for liability purposes, even if there was a technical glitch in the formal creation. For this doctrine to apply, the owner must generally show two things. One, that they made a good faith effort to comply with the incorporation requirements. They genuinely tried to file the papers correctly. And two, that they operated the business as a corporation without actual knowledge of the defect. They honestly didn't know they messed up. If these conditions are met, the entity is treated as a corporation for most purposes, which critically limits the personal liability of the individuals involved.
Okay, so good faith attempt, no knowledge of the defect. That's de facto corporation. What's the second way they might avoid personal liability?
The second escape hatch is corporation by estoppel. This doctrine is a bit different because it's typically limited to contractual agreements and focuses more on fairness to the third party involved in the transaction.
How does estoppel work here?
It applies when a third party dealt with the entity as though it was a corporation. If they treated it like a corporation, signed contracts with XYZ Corp., maybe relied on its corporate status, then that third party will be estopped or legally prevented from later denying the entity's corporate existence just to try and hold the individual shareholders personally liable. It's like the law saying, hey, you treated them as a corporation when it suited you, like when making the deal. You can't suddenly claim they weren't one just because the deal went sour and you want to sue the individuals. It protects individuals who genuinely believe they were dealing with a corporation, especially if the third party also treated them that way.
So let's put this into a bar exam context. If a third party tries to sue a shareholder personally for breach of contract by the corporation, these are the key defenses you'd analyze for the shareholder, right?
Yeah.
Promoter liability first, then these defective incorporation doctrines.
Precisely. When you see a fact pattern where a third party is suing a shareholder for breach of contract, your analysis should follow a clear path. First, always check promoter liability. Is the person being sued the promoter, and did an ovation occur? If not, they might still be on the hook. Second, assess the corporation status. Was it a de jure corporation, validly formed? If yes, shareholders generally have no personal liability unless the very high bar for piercing the corporate veil is met, and we'll get into that later, but think fraud, undercapitalization, alter ego issues. But if the corporation was defectively incorporated, that's when you immediately pivot to analyzing de facto corporation. Good faith effort, no knowledge of defect, and/or corporation by estoppel. Third party treated it as a corporation in the contract. Can either of these doctrines apply to shield the shareholder from personal liability in that specific contractual dispute? These distinctions are absolutely critical for understanding who bears the risk when incorporation goes wrong. And this really highlights those crucial legal distinctions that can literally save individuals from enormous personal financial risk. It's the difference between losing the money you invested in the company and potentially losing your house, your savings, everything you own personally. For someone prepping for a legal exam, these specific doctrines, de facto corporation and corporation by estoppel, are classic areas. Examiners love to test your ability to apply these nuanced rules to complex fact patterns. It's all about recognizing that a good faith effort, even if flawed, can sometimes still offer significant legal protection.
So we've navigated the tricky waters of actually getting a company born, dealing with promoter issues, and even what happens if the birth isn't perfect. But once it's officially on the books as a de jure corporation, or maybe even a de facto one, how do you actually own a piece of it? That's where stock comes in, right? The very essence of corporate ownership and how companies raise money.
Exactly. Stock isn't just, a fancy piece of paper or a number on a screen. It intrinsically represents an ownership interest, a slice of the pie in the corporation. And holding that stock grants specific rights to the owner, the shareholder. It's the primary mechanism through which a company raises capital from investors, and it's how ownership gets distributed among them.
And I know there are different types, different flavors of stock, right? What are the main kinds a typical corporation might issue?
Yes. Primarily two fundamental types you need to know called. First is common stock. This represents the basic fundamental ownership interest. It typically grants voting rights on matters of corporate governance, like electing directors, or approving major corporate actions like mergers. Common shareholders are usually the last in line to get paid if a company liquidates, but they also have the most potential upside if the company really takes off.
Okay, common stock is the baseline. What's the other main type?
Then there's preferred stock. As the name suggests, it grants the holder some form of preference over common stock, most commonly regarding distributions, especially dividends. If a company declares dividends, Preferred shareholders typically get paid their fixed dividend amount,